disappeared beside me, Lord Henley.
I can only apologise, my Lord. As I ought to apologise also for the difficulties that some people, including myself, are having with the electronic bundler. We suspect it may be something to do with the software that each individual is utilising, but I found that the highlighting facility was there, but so slow that it became impossible to use.
I think we're all experiencing the same.
Yeah. We did delegate this task to a professional Supreme Court electronic bundle composer, so I don't know why it doesn't work with every rate of software. I can only apologise, my Lord, and if we can do something more overnight, we will.
Well, I hope that in due course we'll have an electronic version of the bundle that does work and can be annotated.
Yes.
Because we'll need that.
Yes, as I say, the difficulty may be the software that one is using, but I'll leave it to those that understand these things. My Lady, my Lords, we were looking at the case of Manole, and I'd got to page 3020 in the bundle.
You have to bear with us for a moment.
3020.
Can you just bear with us for a moment, please?
And there's just a few passages more to pick up. In paragraph 53, the European Court says, they, that's the farmers, stated that the aim of the right of association was to enable democracy to be exercised in the employment relationship, particularly as regards employers. Accordingly, the fact of restricting that right vis-a-vis persons, I'm so sorry, it's not they, they is the government, stated that the aim was to enable democracy to be exercised in the employment relationship, particularly as regards employers. Accordingly, the fact of restricting that right vis-a-vis persons who, like self-employed farmers, did not have a contract of employment, did not amount to a violation of Article 11. And there's more submissions. And the European Court at 59, paragraph 59, say, although the Convention doesn't precisely define the concept of trade union beyond a general indication that it's an association formed for the purpose of defending the interests of its members, most of the cases considered by the Court have concerned employees and, more broadly, persons in an employment relationship, see syndicatal. Nevertheless, there's a sensitive nature, proper balance, and so on. And I pick it up then at 62 under application of the principles of the present case. Court reiterates that 11.2 of the Convention doesn't exclude any occupational group. In the present case, insofar as the applicants were refused the right to be registered as a trade union type association, the Court considers there was an interference by the respondent state with the exercise of the rights guaranteed by Article 11 of the Convention. Court notes parties agreed the impugned interference based on provisions of law. At 64, it follows that the impugned interference was prescribed by law. 65, Court further considers that the interference pursued a legitimate aim. That's to say, the protection of the economic and social order by maintaining the legal difference between trade unions and other types of association. And at 65, pursuant to this case law, the case Court can't consider this without taking into account relevant international instruments, and in particular the ILO conventions, and then it discusses those. But at paragraph 71, having discussed the various conventions, the last sentence says, the Court discerns no sufficient reasons to deduce from those general observations that the exclusion of self-employed farmers from the right to form trade unions amounts to a breach of Article 11 of the Convention. On the other hand, it observes the legislation in force in no way restricted the applicant's rights to set up a trade association. And 73, domestic legislation grants agricultural trade organisations the requisite rights for defending their members' interests without any need to establish such organisations in the form of trade unions. and 75, therefore no violation. So what the court did was to hold that these self-employed farmers were protected by Article 11 in their desire to establish a trade union for the purposes that they set out, which were not confined to collective bargaining or right to strike or anything of that kind, but the court held that under Article 11(2), there was an interference with that trade union right, but nevertheless it was a legitimate interference and permissible under Article 11(2). So the case is very significant in our respectful submission on the breadth of the interest protected by Article 11(1).
Lord Henry, I wonder if you could help me in relation to paragraph 73. It says the need to establish such organisations in the form of trade unions, which are now reserved for employees and members of cooperatives. Well, is there case law about members of cooperatives? What do you understand?
Not so far as I'm aware, Lord, no.
And what is meant by members of cooperatives as opposed to employment-type relationships?
Well, presumably it means that those who have come together to form a cooperative organisation for doing whatever it is, whatever task in agricultural,
is that a trade union?
Production of crops,
Is that a trade union or not?
But they won't be employed by the cooperative. They'll be, as it were, partners in the cooperative, presumably.
Yeah.
This is just a statement of the relevant domestic law of the state in question, as I read the paragraph.
Right. That's yes. As I understood it, yes.
But I'm not sure that I get from this case that the court was holding that they were entitled under Article 11 to form a trade union as opposed to a trade association.
Well, my lord, it must be so because the interference was found to be justifiable because they could form a trade association. But one wouldn't get to 11(2) if they were excluded from 11(1). And the reason that they're protected, there was on the face of it, a violation of Article 11(1), was that they were denied the right to form a trade union. But that denial was justified in accordance with 11(2).
Just which paragraph do you rely on for that?
I've lost my place, of course, now, my lord. Sorry. Just give me a moment.
It's correct that they don't answer the conflicting arguments put forward on behalf of the appellants and the government at paragraphs 39, 40 and 41.
Yes. We think really from paragraph 59 onwards, it's not stated in terms I accept. But the reason that in paragraph 62 they go on to consider the application of 11(2) and find that the interference was justifiable, and in paragraph 71, that last sentence, it must be where they say no sufficient reasons to deduce the exclusion of self-employed farmers from forming for trade unions amounts to a breach of Article 11. That must be because the exclusion would have been a breach of Article 11(1), but was justified under Article 11(2). Otherwise, the case would have failed in limine. Or as my learned friends would say, Article 11(1) wasn't engaged. But what the case in our respectful submission shows is that entitlement under Article 11(1) to the trade union rights doesn't depend on being an employee and doesn't depend necessarily on being in an employment relationship. Otherwise, they'd have been excluded on that ground to begin with. If an employment relationship is not the definitive criterion, and in this case it appears that the applicant's mere assertion that they wanted to form a trade union was sufficient to bring them within the scope or the engagement of Article 11(1), then the question is, what is the significance of an employment relationship? Clearly, it's an important factor, as the Good Shepherd case shows, but we suggest that what it represents is a form of shorthand for a purposive interpretation, namely the applicants seeking to protect their interest through trade union action.
Is there any limit imposed on the scope of 11(1)?
Is there anything? I'm so sure.
Any limit imposed on the scope of 11(1)?
Nothing more than your lordships and ladyship have seen.
To form an association.
So sorry.
Is it enough, simply enough, that any group of persons want to form an association?
It is for the purpose of the first part of 11(1), freedom of assembly and freedom of association, clearly. But we accept, as the cases have shown, that the right to form and join a trade union for the protection of one's interests is a special aspect of that general freedom of association. So there was discussion below, for, as your lordships and ladyship will recall, about a bunch of supermarket customers and whether they could form a trade union. And the answer to that in our respectful submission is yes, they could form an association, clearly, and they would have a collective interest in that prices or availability or number of tills and what have you. But could they form a trade union? We would respectfully suggest not, because they have no occupational interests to protect through the medium of trade union rights. A collective of supermarket customers don't seek to regulate their terms and conditions of work by collective bargaining, for example. And even if they did have such a...
Say that you said before, supermarkets customers cannot form a union because, and what was the sentence that you said then?
Because they have no interest to protect through the medium of trade union action.
I think you said occupation.
Yes. I think you said no, because they could not form a trade union because they had no occupational interest to protect through trade union rights.
My Lords, my Lady, what I've got in mind, and perhaps I should come to it immediately and then return to the question of supermarket customers in just a moment. What I've got in mind is the passage in Damia, which your lordships and ladyships saw, which says the words for the it's paragraph 140 of Damia at 2902, and in Wilson and Palmer was the same effect found in paragraph 42 at 2884. And I just read those words. The words for the protection of his interest.
Forgive me, you're reading from Demir or from?
This is from Wilson, and I'll tell your lordships the one-word difference in Damir.
Right, so this is page
2884, paragraph 42, Wilson and Palmer in the United Kingdom.
Paragraph 44.
42, my lord.
42, thank you.
The words for the protection of his interest in Article 11, paragraph 1 are not redundant, and the Convention safeguards freedom to protect the occupational interests of trade union members by trade union action. Now, Demir at 140, which your lordships and ladyship looked at earlier, at paragraph 140, page 2902, says exactly the same thing, except it substitutes by the union's collective action at the end instead of by trade union action.
Just going on.
So with those words in mind, what we say about the supermarket consumers
Well, they're not occupational interests, is your
they've got no collective occupational interest. Each one of them may have an occupational interest, although some might be retired or
not as a consumer of not as a customer at the supermarket.
exactly so. No occupational interest to protect, and no occupational interest to protect through trade union action. Now, of course, one accepts that in Manole, the trade union action was cast pretty widely, because it wasn't confined to collective bargaining. It seemed to be looking at ways in which the entire agricultural industry could be transformed, but nevertheless the court seemed to accept that that was a legitimate form of...
When you say occupational interest, and that's what makes the union a trade union, which is, I think, broadly what you're saying, what you mean is, at its core, work, pay and hours and holidays and other things as well. But if it's only other things, then it's probably not a trade union. Would that be fair?
Lady, I think that is what we're saying. We're saying it's to do with work and the terms and conditions of work. All the things that are set out in Section 178 as a typical description of collective bargaining.
But the term occupational interest is far too wide, because it would include those people who have clients of their own.
It could do, my Lord.
Yeah, and it shouldn't do.
Yes. But those are the words that the Grand Chamber on two occasions, or one occasion, and a section of the...
That may be in the context of Article 8 actually, being within the scope of Article 11 on the basis of an employment relationship. And then you do have occupational interests.
Yes, yes.
Yeah. So,
of course, occupational interests can go a lot wider. They could involve training and education and all sorts of things. Clearly, discrimination would be one, and so on. But it gives an indication. It's something to do with the fact that those who are seeking to assert Article 11 are workers at work, and it's to do with their work. And it's confined by the fact that, by the requirement that those occupational interests must be capable, at least in theory, of being advanced by trade union collective action. Of course, trade unions have a lot of collective activities, but the key one is, of course, collective bargaining. And it's that which certainly in UK law, which is the defining characteristic of a trade union. Your lordships have got the statute there, but probably familiar with it. It's Section 1 of the Trade Union Labour Relations Consolidation Act 1992, which says that a trade union has amongst its principal purpose must be the regulation of relations between workers and an employer or employers. And that regulation of relations is, of course, a reference to collective bargaining. They include the right to strike and so on, but principally it's collective bargaining. So that
the concept of the right to form and join a trade union doesn't apply to everyone. It applies to a restricted group of people.
Yes.
How do you define the restricted group?
How do we...
Yes.
Well, our submission is that it has to be defined by reference to the objective sought to be obtained by the group. If their objective is simply to set up a betting syndicate, then they're not forming or joining a trade union. If their objective is to do something about their terms and conditions of employment by collective bargaining, whatever else might be included, that puts them in the realm of trade unions and trade union action to fulfill their occupational interests.
But you there said terms and conditions of employment.
Yes.
So what does employment mean?
The term, loose language again, my lord, it's the terms and conditions on which they work, the terms and conditions on which they're engaged, the terms and conditions on which regulate the work that they do and on the one side and the remuneration they get on the other.
But when the BMA negotiates on behalf of junior doctors with the, that's a bad example. So take the Criminal Bar Association negotiating the terms of criminal legal aid. Is it entitled to be registered as a trade union under Article 11?
Well, my lord, I would submit that they would be entitled to do so. Now, they may run into difficulties with the competition authority because it may be said that their barristers are undertakings within competition law because they're businesses with their own clients, customers, and therefore they're forming a cartel. But so far as trade unions are concerned, it is also and always has been regarded as a cartel activity in restraint of trade, and we set out in our case some of the historic litigation and legislation which allows trade unions to perform as a cartel on behalf of workers. So the CBA may be in a slightly different position. The BMA, however, is quite clearly a trade union.
Yeah, that I understand.
And then if you had an association of self-employed farmers and they operated as a cartel, that would be unlawful.
If they operate, yes, and they operate as a cartel if they are businesses in business on their own account with their own clients or customers, and if they are not in business on their own account, if, like these riders, they're providing services collectively to a particular entity which controls the terms and conditions on which they're engaged, then they're excused competition law. They're not acting in restraint of trade. And that's the difference. I appreciate that we're straying a little bit away from the European court jurisprudence, but that's a fundamental distinction between the two classes of self-employed identified by Lady Hale in the Bates von Winkelhoff case and by Lord Clark in Avrani. The difference between those in business on their own account with their own clients and those whose can't regulate their own terms and conditions or in a relationship of dependency with an entity which fixes those terms and conditions. Lord, Lady, I come now to the question of a purposive construction of Article 11 Article 11. There's a case which we cite in our written case called the Irish Confederation of Trade Unions in Ireland. It's in the bundle, electronic bundle at page 3323. It's a decision of the European Committee on Social Rights we set out in our written case paragraphs 37 and 38 in our case, which is in the electronic bundle at page 188 to 189.
Paragraph.
And in the key documents, it's at pages 30 to 31.
So do you mean paragraph 31?
Paragraphs 37 and 38.
Oh.
In key documents, it should be page 30 and 31.
Oh, sorry,
is it not?
I'm in the...
In the electronic bundle, it's page 188 to 189.
Yeah, that seems to be the Court of Appeal judgment.
Sorry? So can you just...
Sorry, page 88 to 89.
Of...
That's the case.
The electronic one.
Thank you. I'm sorry.
Yeah.
Forgive me, I don't know how I got that wrong. I think that was the report of the case itself.
This is quotations from the Irish Congress.
Yes, it's the Irish Congress of Trade Unions and
Sorry, you've lost me. I'm looking at your case, paragraph 37.
no, 42.
Oh.
Yes.
Right, and what's that authority for?
I just wanted to. This authority is authority for the fact that self-employed workers also have the right to collective bargaining, and that's supported by a whole mass of ILO and other material which we set out in the written case, and I won't belabor your lordships and your ladyship with this afternoon. But at paragraph 38, they give a rationale for that, and I read paragraph 38. Moreover, the committee emphasises that collective mechanisms in the field of work are justified by the comparably weak position of an individual supplier of labour in establishing the terms and conditions of their contract. This contrasts with competition law, where grouping of interests of suppliers endanger fair prices for consumers. To overcome the lack of individual bargaining power, the anti-cartel regulations are considered inapplicable to labour contracts, and this has been generally accepted by the Court of Justice of the EU, see Albany. In establishing the type of collective bargaining that is protected by the Charter, it's not sufficient to rely on distinctions between worker and self-employed. The decisive criterion is rather whether there's an imbalance of power between the providers and engagers of labour. Where providers of labour have no substantial influence on the content of contractual conditions, they must be given the possibility of improving the power imbalance through collective bargaining.
Whereabouts does the Strasbourg Court adopt that as one of the factors?
I'm so sorry, Lord.
Where does the Strasbourg Court adopt that last sentence as one of the factors?
It doesn't.
It doesn't. Yeah.
Nowhere is there an explicit appropriation of that sentence. But nevertheless, we do say that the phrase "for the protection of his interests" at the end of 11.1 must necessarily incorporate that line of thought. That line of thought has also been found to be the basis of a right to collective bargaining, which was established in the Canadian Supreme Court in a case which we've cited in our written case. It's called the Mounted Police Association of Ontario. In the electronic bundle, it's at page 3381 at tab 100. And in our written case, we've set out extensive citations from the judgment of Chief Justice McLachlan in the majority in the Canadian Supreme Court. And I read just a short passage from paragraph 70 and 71, which in the electronic bundle are at 3426 to 7. And in paragraph 70, the court says, as we have seen, section 2D. Now, section 2D is the part...
This is your case, paragraph...
It's paragraph 70, my lord.
Of your case?
No, of the judgment of the Canadian Supreme Court, which your lordship has in the electronic bundle at 3426.
Thank you. What was the reference to your written case then?
In our case, it's at... I'll give you the paragraphs numbers. In the key documents, it's pages 21 to 23. It's paragraphs 15 to 17.
Thank you. Thank you.
And at paragraph 70 of the Canadian Supreme Court judgment, picking up, it says, as we've seen, section 2D. Now, section 2D is the section of the Canadian Charter of Fundamental Rights which protects freedom of association. As we've seen, 2D functions to prevent individuals who alone may be powerless from being overwhelmed by more powerful entities, while also enhancing their strength through the exercise of collective power. Nowhere are these dual functions of section 2D more pertinent than in labour relations. Individual employees typically lack the power to bargain and pursue workplace goals with their more powerful employers. Only by banding together in collective bargaining associations, thus strengthening their bargaining power with their employer, can they meaningfully pursue their workplace goals. The right to a meaningful process of collective bargaining is therefore a necessary element of the right to collectively pursue workplace goals in a meaningful way. Now, of course, this is no more than persuasive precedent in relation to this court's establishment of what the European Court of Human Rights might think, but it's significant that it, as it were, chimes with the Irish case. It also chimes in our submission with the purposive approach of this court to employment rights more generally, taken in the Auto-Cleanse case and in Uber. Also, I'm very mindful of the time now, but in the Uber case, which is at 2487 of the electronic bundle, Lord Leggett, with whom all members agreed, Lord Leggett at 2503, paragraph 63, began by citing the judgment of this court given by Lord Clark in Auto-Cleanse, paragraph 35 at 1770. And the theoretical justification for that approach was explained by Lord Leggett at paragraph 68 to 70, to which I would like now to draw attention. It's page 2504 of the electronic bundle. In paragraph 68, His Lordship says, the judgment of this court in Auto-Cleanse made clear that whether a contract is a worker's contract within the meaning of the legislation is designed to protect employees and other workers is not to be determined by applying ordinary principles of contract law, such as the parole evidence rule, the signature rule, principles that govern the rectification of contractual documents on grounds of mistake. In 69, he says, critical to understanding the auto-cleanse case as I see it, is that the rights asserted by the claimants are not contractual rights, but created by legislation. Thus, the task of the tribunals and courts was not, unless the legislation required it, to identify whether under the terms of their contracts auto-cleanse had agreed claimants should be paid at least the national minimum wage or receive annual leave. It was to determine whether the claimants fell within the definition of a worker in the relevant statutory provisions so as to qualify for these rights irrespective of what had been contractually agreed. In short, primary question was one of statutory interpretation, not contractual interpretation. And then your Lordship see what's said at paragraph 70, concluding the ultimate question is whether the relevant statutory provisions construed purposively or intended to apply to the transaction viewed realistically. In 71, the general purpose of the employment legislation invoked by the claimants in auto-cleanse by the claimants in the present case is not in doubt. It is to protect vulnerable workers from being paid too little for the work they do, required to work in excessive hours, or subjected to other forms of unfair treatment, such as being victimised. The Paradigm case and so on. And reference is made to...
He's not saying that that's the definition of those who benefit from this. He's saying that's the underlying purpose at which the definition is aimed. Is that fair?
Exactly so, my lady. And what I'm suggesting is that grappling with the underlying purpose is common in all these different jurisdictions and must be applied to Article 11, which specifically has those words for the protection of his interests attached to it. And then just below letter F on page 2505, citation from Mr. Recorder Underhill, as he then was in Byrne Brothers. The policy behind the inclusion of Limb B can only have been to extend the benefits of protection to workers who are in the same need of protection as employees, stricto sensu. Workers, that is, who are viewed as liable, whatever their formal employment status, to be required to work excessive hours or suffering unlawful deductions from their earnings or paid too little. And then I take you, Lordships, your Ladyship, to paragraph 75 on 2507 as reference under the indented quotation to an illuminating discussion by Professor Guy Davidoff. It's these features of work relations which give rise to a situation in which such relations cannot safely be left to contractual regulations are considered to require statutory regulation. And in 76, just at letter F, his Lordship says, the efficacy of such protection will be seriously undermined if the putative employer could, by the way in which the relationship is characterised in the written contract, determine even prima facie whether or not the other party is to be classified as a worker. And in 78, his Lordship says, this is, as I said, the relevance of the emphasis placed in the auto-cleanse case on the relative bargaining power of the parties in the employment context, and the reason why Lord Clark described the approach endorsed in that case of looking beyond the terms of any written agreement to the parties' true agreement as a purposive approach to the problem. And in 80, these provisions of statutory provisions, as I read them, apply to any provision in an agreement which can be seen on an objective consideration of the facts to have as its object excluding or limiting the operation of the legislation. It's just as inimical to the aims of the legislation to allow its protection to be limited or excluded indirectly by the terms of a contract as it is to allow that to be done in direct terms.
So he's saying that you can't just say at the front of your contract with the person who's providing you with services, you are not an employee, you are not in the employment relationship, you are completely self-employed and you don't have these rights. That is not determinative. But you say it goes beyond that,
yeah,
to say that even looking at the particular terms and conditions rather than the badge put on them by the employer, you still have to look at those to determine whether they show anything about the nature of the relationship so far as whether it's within scope of Article 11.
Yes, we say that under the UK legislation, Uber now defines the approach of the courts, and employers can say, of course, whatever they like in their contract. They can say all rights are excluded. You are a self-employed worker, and so on. But if the purpose and effect of whatever clause they insert is to remove protection, then a statute may overtake that, or it's but be that as it may, in UK law, all we can take from it for the purposes of the exercise on which your lordships and your ladyship are concerned this afternoon is that that purposive approach is shared by other jurisdictions and must be shared, we say, by the European Court of Human Rights. And that really is why we say that the reference to an employment relationship in the Good Shepherd is a sort of shorthand for the purposive exercise which is set out in those authorities. And in the instant case, given the total refusal of Deliveroo to negotiate or even consult riders or their trade unions about the terms and conditions on which they're engaged, and the obvious inequality of bargaining power, reduction of that disparity through the exercise of the right to bargain collectively is called for in accordance with the intuition which was expressed by Lord Justices Underhill and Coulson in that case. Lords, I turn next to the question of the interaction between Article 11 and Schedule 1, because it's not obvious, of course, at first glance, why, if we're right that we're protected by Article 11, why that should guarantee our crossing the threshold into the Schedule A1 machinery. And the answer to that, my Lord, is 3 cases in the Court of Appeal, which we submit respectfully, are all correct in saying that Article 11.1, not in every case, but in many cases, or in every case, is capable of guaranteeing admission to the portal, although not in every case. Lords, the passages are set out in our written case, but I'm going to show your lordships and your ladyship the 3 cases in the electronic bundle. The first is Pharmacists Defence Association and Boots. This is at 2145, tab 41, decided in 2017.
Reference to your written case as well.
It's in our written case as well, yes, my Lord.
Is where?
It is it's at in the key documents. It's at page 58, paragraph 125.
Thank you.
And in the electronic...
116 in the electronic one.
1116. Right. Sorry, that's our skeleton argument, yes, our written case. But I want the electronic bundle, which is 2145. Was the relevant passages in the judgment of the Court of Appeal, or at least the discussion which leads to the conclusion in paragraph 54 is a discussion which starts at paragraph 33, which is at 2149. It begins with a discussion of Damia. At paragraph 39, it deals with the case of Unite in the United Kingdom. And there is a discussion which concludes in paragraph 54, which is, I think, all I need to draw to your lordships and your ladyships' attention this afternoon. Paragraph 54 at page 2153, and I read it in full. My conclusions in this case are largely determined by what I've already said about the effect of the Strasbourg authorities. It follows from the recognition by the court in Demir that the right to bargain collectively with the employer is an essential element of the rights protected by Article 11, that a complaint that domestic law doesn't accord such a right in a particular case will fall within the scope of Article 11. But at the risk of spelling out the obvious, it doesn't follow from that Article 11 confers a universal right on any trade unions to be recognised in all circumstances. Self-evident that any right to be recognised conferred by domestic law will have to be defined by rules which identify which unions should be recognised by which employers in respect of which workers and for what purposes. To the extent that the rules of any such scheme constrain access to collective bargaining for a particular union or its members, the constraints will have to be justified by, to use the language of Unite, relevant and sufficient reasons, and should strike a fair balance between the competing interests at stake. But the decision also makes clear that in assessing any such justification, the state should be accorded a wide margin of appreciation. Now, that ratio was confirmed by the Court of Appeal in a later case.
Sorry, could I get some assistance as to what we're to take from this? My understanding is that Article 11.1, the concept as to whether or not you can join and form and join a trade union is an autonomous concept. There's no margin of appreciation at all. And what we're searching for is the test that's applicable. And then when you go to 11.2, then there's a margin of appreciation.
Yes.
And so what more is there to it?
Well, it's to get over the... Once one accepts that 11.1 protects the right to join a form a union, and as an essential element of that, the right to bargain collectively, does that enable applicants to cross the portal into Schedule A1?
I'm not certain I follow it, because Article 11.1 refers to two things: associations and trade unions.
Yes.
And then it goes on to say, well, if you're a trade union, then you've got a right to collective bargaining.
Yes.
And so it's not the right to collective bargaining, it's the right to be a member of a trade union that is determinative.
Well,
is the point, sorry.
Yes?
I was just going to say, is the point whether Article 11 confers a right on trade unions to compel employers to negotiate? There's no decision of Strasbourg that goes that far at the moment, but you're saying certainly in certain circumstances
I don't go that
it
far,
should.
Lord. I don't go that far. And the reason I don't go that far is that with Schedule A1, the state has established a procedure for recognition. The question is whether a particular group of workers and their union can be legitimately excluded from that mechanism in the light of Article 11.1.
But isn't that a tendentious way of putting it, arguably? It's one thing to say everybody has a right to form a trade union, and that a trade union has a right to seek to engage in non-compulsory collective bargaining with one or more employers, or, I mean, using employer in a very generic and loose sense. And it's another thing to say that Parliament has chosen to make that compulsory in certain cases. But to describe a structure which is designed to make it compulsory in certain cases, although not prohibited in any cases, as a statutory, I'm looking at your case, a statutory barrier to the compulsory collective bargaining mechanism, it could be said to be standing it on its head. And the question is, where has the state chosen to draw the line in terms of compulsion?
Yes. Well, the Schedule A1 is compulsory in the sense that if the CAC grants a declaration, then the employer must negotiate. Yes. Of course, that's right. But the scheme makes certain exclusions from it. Now, some of those...
Is it exclusions, or is it a scheme which simply includes certain bodies and types of people within it?
Well, it's two sides of the same coin. Perhaps your Lordship thinks it's too tendentious to say excludes, but let us leave it simply that the scheme provides inclusion of certain groups. Yes. But by necessity, that means that certain groups are excluded and without. Now, the question is whether the exclusion of those who can't cross the threshold under the legislation as it stands are entitled to rely on Article 11.1, assuming that they're covered by it, to say, no, that the reason given by the state scheme for not allowing us to cross the threshold violates Article 11.1 and must therefore be justified under Article 11.2. And as we see it, that's what the Court of Appeal are essentially saying. And it's not true of every exclusion, but the question is whether it's true of our exclusion on the ground on which we have been excluded, namely that there is a substitution clause which precludes personal service or has been held.
Aren't we getting here into the discussion of whether the member state has only negative obligations,
yes,
not to prevent collective bargaining by unions representing people who fall within the scope of Article 11 versus whether there's a positive obligation to include everyone who's in the scope of Article 11 in this compulsory scheme, just calling it that as a matter of shorthand. Now, what you seem to be saying is if Schedule A1 didn't exist at all, well then fine, there's no specific legislation preventing collective bargaining, so there wouldn't be any violation. But you say that once the contracting state has in fact enacted a compulsory type regime, then it must include in that everyone who's in the scope of Article 11.
That is exactly as we would put it, my lady. If there had been no such scheme, we would not be in a position to insist that Article 11 required the state to erect such a scheme. We would have no argument. But since the state has erected such a scheme, then the exclusions, we say, must be justified in relation to the European Convention. So if one took an example...
There are examples of cases in the discrimination field where you say, all right, there's no right to marriage, say, but if you're going to have a right of marriage, then it's got to be, or if you're going to have a right, say, to same-sex marriage, there's no obligation under the convention to confer such a right. If you are going to confer such a right, you have to do it in a non-discriminatory way. So you couldn't say, for example, that only people of certain ethnicities could do it. That would be a breach of the convention.
Milady, absolutely.
You seem to be sort of borrowing that kind of concept to apply it here, to say, not really, you're not relying on a kind of discriminatory thing, but you're saying that once you have this regime set up, then it has to cover everybody who falls within the scope of the negative obligation.
Properly covered by it. Milady, absolutely right. So, for example, there's no obligation on local authorities to provide swimming pools, but if they do provide a swimming pool and exclude people because they're black, they will find that is in breach of the European Convention as well as domestic law as well. And we say exactly the same applies here. It is, as your ladyship said at the outset of this part of the discussion, it's the negative obligation on the state not to effectively discriminate in a way that would violate these workers' Article 11 rights. Milady, my lords, I was going to turn to the second of the three authorities that deal with this, and this is the case of Vining in the London Borough of Wandsworth, which is at page 2243 in tab 45. 2243. The issue in that case was whether Parks Police were entitled to be consulted for the purposes of a collective redundancy under Section 188 of the 1992 Act. And the judgment of Sir Terence Etherton, the Master of the Rolls, at paragraph 64.
Sorry, paragraph 64.
Paragraph 64 to 65, which is at page 2263 to 4 of the electronic bundle. And at 64, he says, if accordingly the rights in question fall within the scope of Article 11, the United Kingdom is under a positive obligation to secure the effective enjoyment of those rights. That doesn't mean that it's under an obligation to ensure that they're available to all employees in all circumstances, but it does mean that where a legislative scheme is in place, it must strike a fair balance between the competing interests, and any provision of that scheme which restricts its availability to particular classes of workers requires to be justified, albeit that the state is recognised to have a wide margin of appreciation. Relevant principles in Boots. That conclusion is fatal to the Secretary of State's and thus also Wandsworth's case on the issue of principle. As we've said, is not sought in this case to advance any justification for the exclusion of Parks Police officers.
How does this authority help you, though? Because the issue presumably was whether the Parks Police could join a union, is that right?
Because it's based on the same right to collective bargaining founded in Damia, and your lordship will see that in the discussion which led to that paragraph from paragraph 59 onwards. There's a discussion at 62 about which 61 deals with Damia, and that's developed in the two paragraphs which followed. And the Court of Appeal there considered that the right to consultation over collective redundancies was an aspect of the right to bargain collectively.
Yes, but it's not concerned with what you might call compulsory collective bargaining, is it? Because 64 starts, if accordingly the rights in question fall within the scope of Article 11. So that presupposes that what we're talking about does fall within the scope of Article 11. The question is whether compulsory collective bargaining does fall within the scope of Article 11.
Well, my Lord, with respect, no. In this case, the consultation was compulsory if the workers fell within Article 11.1, which the court held that they did. But that doesn't presuppose that Article 11 upholds the right to compulsory collective bargaining. Article 11 says that there is a right to collective bargaining, and the negative obligations of the state are not to exclude anybody from the possibility of collective bargaining or a machinery for collective bargaining, whether compulsory or not, on illegitimate grounds.
Right. So this concerned compulsory consultation, is that?
It did.
Yes.
It did, my Lord.
Okay,
Yes.
thank you.
Yes. And this is a case, my Lord, lady, where section
In
296 was...
in Article 11 terms, the anterior question is whether or not you can form or join a trade union.
Yes.
And then that depends upon whether it's an employment relationship.
Well,
And subject to your argument about Manel.
yes, yes. So it's whether you can
If
join a
you
trade
don't-
union, and implicit in that, or an essential element of that, is the right to bargain collectively.
Well, yes. The trouble is that in that is it a right not to be prohibited by the state's legislation from bargaining collectively? Answer clearly yes. Is it a right that everyone enjoys to have compulsory collective bargaining? I think you accept the answer to that is no.
That's so.
But what you say, there's an in-between area, which you say that Wandsworth and Vining is authority for, that if you have compulsory whatever, then you have to confer it on everybody who is within Article 11.
Exactly.
Or if you want to only confer it on some of those, then you have to justify the exclusion of others from that, once you've decided to confer that right on some people.
Precisely so, and that goes back to the point which my lady raised a little earlier. If that machinery wasn't there, we would not have a right under Article 11 to compel the state to erect a machinery for compulsory collective bargaining. It's only because the state has erected such a machinery, or in the Vining case, the mechanics for compulsory consultation over redundancy, that the applicants are entitled to say, we've been wrongly excluded from the benefits.
Is that right, Lord Hendy? I'm just looking at the summary of Mr. Stilitz's argument at paragraph 62, and then how the court deals with it in the first few sentences of 63.
Yes.
I mean, they say that the right to be consulted, it falls squarely within the essential elements protected by Article 11. And then they go on to a discussion about collective bargaining. But that's their starting point. So in those circumstances, it's bound to become an 11.2 question.
Yes, well...
I mean, it's different from the right and the obligation which you're seeking to support in this case. That's really the point I'm making.
Yes. Lord, perhaps I'm being a bit dense, but in 62,
yes,
Mr. Stillis is arguing that the right did not include a right to be consulted
correct,
about...
Correct. And then the court
dismissals.
said, no, it does include a right to be consulted.
Yes.
So that is included within 11.1. It's an
Yes.
essential element of the right to join or form
Yes.
a trade union.
Yes.
But the question which this case gives rise to is a different question, namely whether the right to impose collective bargaining on an employer falls within 11.1.
Well, my Lord, I'm sure it's me not appreciating the nuance of your Lordship's question, but isn't it the same or an analogous point? In Vining, there's a statutory scheme which derives from the European Union that employers must compulsorily consult where they're proposing to dismiss 30 or more
Yes.
Workers. And it was said that because the Parks Police were not workers within the definition, they didn't have that right in UK law. They said, well, we are workers within Article 11 and therefore we should have the benefit of that scheme. And the Court of Appeal said, yes, they could. And our argument is with respect, completely analogous. We say, well, here's a scheme for compulsory collective bargaining. You can't exclude us because we're protected by Article 11.1.
And do you submit that the right to compulsory collective bargaining, falls squarely within the essential elements protected by Article 11?
I don't, my Lord, no.
Well, that is the... I mean, I'm not saying this is fatal to your submissions at all, but I am saying that that's a relevant difference and distinction with the Vining case, because that was the premise which is set out in the first sentence of paragraph 63.
It's a bit like the case that some of us were on about holiday pay under the Working Time Directive. There's a right to 4 weeks holiday pay under the Working Time Directive for workers, and there's a right for a wider category of people to more holiday pay because there's an extra week or so conferred by the legislation. But I think in that case it was accepted by everybody that if you're a worker within the directive, but not within the Employment Rights, this was to do with police office, but not within the Employment Rights Act, you only had the Working Time Directive 4 weeks. You didn't have the right to the additional right, which is conferred on a broader range of people.
Yes.
But you would say that once you confer a right on people, some people, then you have to confer it on everybody.
Yes, I'm not sure that that's perhaps the best analogy, my lady. What we're saying in essence is that if there's a scheme which confers rights, and those rights are covered by Article 11.1, and the group of workers seeking them are protected by Article 11.1, then if they're excluded from that scheme, the state must just justify that under Article 11.2. And we think that is what is being said in the first paragraph of 63. It's not that the Court of Appeal are holding that Article 11 conferred the right to compulsory consultation in the event of redundancy. The European Court has never said that, or never said anything about consultation over collective redundancy. What the Court of Appeal is saying, as we apprehend it, is that the right to be consulted is an aspect of the right to bargain collectively, whether or not it's compulsory, and that therefore if the scheme excludes the benefit of such consultation, then it, on the face of it, it falls foul of Article 11.1 and therefore must be justified under Article 11.2.
Can I just say that the Court of Appeal deals with this point of paragraphs 88 and following, and in paragraph 88, Lord Justice Underhill, having referred to Boots, refers to 2 further decisions of the Court of Appeal, which he says approved the proposition that he made in Boots.
Yes.
We have the references is there, and I
Yes.
take it that they do approve that proposition, subject to anything that may be said to us.
I'm advised. Well, the third of the cases, I'm getting a bit anxious about the time now. The third of the cases is the Independent Workers' Union of Great Britain and the Secretary of State for Business,
which is one of the cases Lord Justice Underhill refers to, as it happens.
Indeed, and it's I won't take your lordships to it in view of the time, but it's page 2524, it's tab 53, it's Lord Justice Bean at paragraph 62, which agrees with Lord Justice Underhill in Boots at 54 and Vining at 64. And there's a final Court of Appeal case. Again, I'll give your lordships the reference without taking your lordship to it. Your lordships and your ladyship to it. It's in our written case. It's National Union of Professional Foster Carers. We did look at it earlier. It's at pages 2,472 to 3, especially at paragraph 109, which essentially is an agreement with the approach in Boots and Vining and IWGB. Lords, in the present appeal, my learned friend Mr. Jeans attempted to resurrect the reasoning of the Employment Appeal Tribunal that was overruled in the National Union of Professional Foster Carers case by saying that the possibility that the riders here have of voluntary collective bargaining is sufficient satisfaction of the Article 11 obligation, notwithstanding their exclusion from Schedule A1. Well, as we say about that it is, to say the least, a bold one, given that it's Deliveroo which has the power to bargain voluntarily with the IWGB over these riders, and it refuses absolutely to do it. And the reality of the situation is that if these riders and their union can't pass the threshold into the Schedule A1 machinery, there is no possibility whatever of them bargaining collectively with this employer, which is absolutely intransigent in denying them the opportunity to do so. And we say that the refusal of Deliveroo illustrates precisely the reason why Article 11 is necessary in order to open the portal of Schedule A1. I was going to say something about European Union law, but I'm very conscious of the time, and I'm not going to invade Mr. Jean's time this afternoon. So what I propose to do is, if any issue of European law raises its head in the submissions of my learned friends, I'll deal with it in reply tomorrow afternoon. And I turn briefly to consider the last two headings, which are Article 11.2, assuming that we surmount the Article 11.1 hurdle, which is the very essence of the case. And Lords, the points that we make there are, Lordships have looked at the requirements of Article 11.1, necessity in a democratic society for one of the specified purposes of which the only one that raises its head is the rights and freedoms of others, in particular Deliveroo. We say denial of the right to access Schedule A1 for the reasons that we are debarred from Schedule A1 is not of a kind which is necessary in a democratic society in order to protect the rights of Deliveroo. And we make, I think, 8 very short points in support of that submission. First of all, the right to bargain collectively is an essential element of Article 11.1, what was referred to in the context of the right to strike as a core right in the RMT and United Kingdom case. Secondly, its purpose is to remediate the imbalance of power at work and therefore to protect the interests of the workers seeking to exercise it. Thirdly, as Demir and many other cases makes clear, that right must be given practical and effective protection. Fourthly, restrictions on the exercise of that right must be construed restrictively. Fifthly, the rights and freedoms of Deliveroo are not impacted to any significant degree, and certainly no right or freedom protected by the European Convention is pointed to by Mr. Jeans. Sixthly, in consequence of any interference with Deliveroo, in consequence, any interference with Deliveroo must be such as to generate an indisputable imperative, a phrase which we cite from the case of Chassagne and France. It's in our paragraph 82 of our written case. It's in the electronic bundle at page 1101. And it's in our, it's paragraph 82 of the judgment at page 1101 of the electronic bundle. It's cited in our case at key document 43. And I'll just tell you, Lordships, Your Ladyship, what that paragraph
1101 isn't turning up anything.
Is it not?
That's page 101 of the electronic bundle.
101?
Yes,
Page 101?
of the written case.
Oh, I see. Sorry, I was given 1101, so it's 101 of the written case.
Is paragraph 82.
Thank you, yeah.
Or key bundle 43, which contains the written case at paragraph 82.
Yes,
And the reference is there to the electronic bundle. I'm so sorry there's so many references and cross-references here. My seventh point is that to the extent that Deliveroo is inconvenienced, assuming a declaration by the CAC, the inconvenience is only trivial. Deliveroo is only required to negotiate and not to agree. There are other consequences which follow recognition, whether voluntary or compulsory. But ultimately, the obligation is simply to talk, to negotiate pay, hours and holidays and not to agree them. And finally, the remaining consequences are no more than any other employer with a recognition agreement undertakes. The Office of National Statistics shows us that around 25% of the British workforce is covered by a collective agreement, which presumably means that only about 25% of that 25% of the workforce has a union which is recognised, and all of them undertake the consequential obligations.
So 25% of the workforce
covered by a collective agreement.
There may be others who have recognised the union but not managed to arrive at a collective agreement.
Absolutely. Many others will be. I think it's about 6.5 million trade union members and a workforce of 31 million. So that's a fifth. That's about 20% of the workforce who are union members, but many of those union members will be members of unions which are not recognised. So there's not a perfect correlation between union membership and collective bargaining coverage. And that's because for many employers it's simply easier to go along with a collective agreement. And collective agreements always cover all the workers in the bargaining unit, whether or not they're members of the particular trade union. So the correlation doesn't match quite. Lords, we can provide those statistics overnight if the slightest help. Lords, Chassagne and other cases illustrate that the pressing social need, which is another way that necessity in a democratic society is expressed in the cases must be proportionate to the legitimate aim, and that in this case presupposes a legitimate aim. Learned friend Mr. Stillitz identifies in his case the rights and freedoms of employers to elect whether or not to enter into collective bargaining on a voluntary basis. Of course, we recognise that that is an interest, but it appears to us that is a flimsy justification which does not warrant the violation of an essential element of Article 11 and doesn't provide a legitimate aim for excluding from Schedule A1 this group of workers. He also says that it's necessary to maintain a detailed and technical scheme of rules which balance and calibrate the interests of multiple stakeholders. That too, in our submission, is a light counterweight to the legitimate aim of the riders to be protected by enabling their union to be heard in negotiations on pay, hours and holidays. There's a lot in our case and in the other cases about margin of discretion, but in our respectful submission, margin of discretion and on reflection, margin of discretion doesn't resolve this case. In our respectful submission, the balance of interest is so overwhelming in favour of the workers when one gets to Article 11.2 that your lordships needn't be troubled about the margin of discretion. Margins of discretion and Article 11.2, of course, weren't dealt with by the Court of Appeal.
Is there some minimum number of employees for an employer in relation to which the Schedule A1 applies?
The number of employees covered by collective bargaining under the CAC.
Yes, does Schedule A1, is it limited to employers who have a certain number of employees? Yes.
Well, there's got to be a minimum of 20 employees. 21, thank you.
21 employees. So that you might be prepared to accept is something which pursues this legitimate aim of not burdening a small employer with the paraphernalia of Schedule A1, and that would be within the margin of appreciation of a state as to where to set that boundary between big and small employers.
Certainly, my lady, I would accept that, and there are other restrictions in the conditions that the CAC must fulfill, which would equally fall within the margin of discretion, such as the factors to be taken into account in identifying the appropriate bargaining unit, which I won't weary the court with. So it's not every ground of exclusion which is protected by Article 11.
Lord Hendy, you have about 5 minutes of your allocated time. Are you going to deal with the question of reading down?
I am, and may I say a few words about that briefly without invading Mr. Jean's allocation. Lords, my lady, the leading case, of course, is Gaidan and Godin Mendoza, which is at tab 25, electronic bundle 1515. Strong presumption in favour of an interpretation consistent with convention rights, that's paragraph 50, and that the meaning imported by the application of Section 3 of the Human Rights Act must be compatible with the underlying thrust of the legislation, must go with the grain of the legislation. I know your lordships are only too familiar with those words. Well, the purpose, the grain of the legislation here is clearly the protection of workers, and in relation to Schedule A1, protection of workers by the scheme of collective bargaining which Parliament has erected. Well, so far as the form of wording, to facilitate reading down in Vining and the London Borough of Wandsworth at paragraph 74, which your lordships have at electronic bundle 2266, the Court of Appeal found no reason to identify a particular form of wording other than to say that a person's employed as constables by virtue of Article 18 of the relevant legislation should be entitled to the right under Section 188 of collective consultation over redundancy. And in the National Union of Foster Carers case, which your lordships have, it's paragraphs 147 to 152, it's page 2483 to 4, the Court of Appeal was similarly content to read down Section 2961 to extend the definition of a worker to foster carers without spelling out the precise words needed to achieve that objective. Lords, the Court of Appeal didn't deal with this. We did make submissions to them about it, but we presented possible formulations which would of words which would achieve the purpose we say should be expressed. In the skeleton argument we presented to the High Court, which your lordships have at page 393 to 398 of the electronic bundles, in our paragraphs 102 to 111, which we slightly reformulated in the Court of Appeal in our skeleton submission to it at 323 to 325 of the electronic bundle, in paragraphs 59 to 67. Lords, we say that it would be sufficient in accordance with Section 3 of the Human Rights Act, so far as the appellants are concerned, that the provisions of Section 2961B construed so as to give effect to its Article 11 rights don't exclude the appellant union from applying to be recognised for the purpose of collective bargaining by Deliveroo in respect of pay hours and holidays of its members.
And so when you read it down, what's left? What's the test that has to be applied after you've done a bit of reading down?
Well, all we seek is a reading down which enables this group of workers not to be excluded on the grounds that it has been excluded. We don't suggest that there's a general proposition here that applies to any other workers, because not many other workers will have the same circumstances of employment, and in particular the same substitution clause in it. And we don't suggest that the effect of reading down 2961B will give these workers any rights other than admission to the Schedule A1 portal. So it's a very, very confined exercise, giving only the protection that is necessary for these workers in this situation. Lords, unless Miss Newton and Miss Stanley tell me that I've missed some crucial matter, those are our submissions.
Anything further? Thank you, Lord Henry.
Thank you.
Please, your lordships and your ladyship, we propose to follow the following structure, which largely, but not entirely, mirrors the course of our written case. First, I would like to address you in support of the proposition that the claimants, the appellants in this court, cannot show that the relationship between Deliveroo and the riders is an employment relationship for the purposes of Article 11. So, point one, no employment relationship. 2, we will submit that collective bargaining rights under Article 11 are limited to employment relationships. 3rd, we will submit that in any event, whether we're right or wrong about 1 and or 2, the Article 11 right does not entail a right to compulsory bargaining. That's to say, bargaining under state compulsion. And that of itself, we say, is the end of the claim. But 4th, we say, if we're wrong on any of the above, either that the Article 11 right isn't limited to an employment relationship, or that riders do have employment relationships with Deliveroo, and the right extends to compulsory bargaining, we say that nonetheless the appellant cannot establish that the right applies to this relationship in these circumstances. These individuals have very special characteristics, and they do not fit the terms of the statutory scheme. If there is even a potential breach of Article 11 in relation to other individuals, there is not in relation to this group. All those 4 lines of argument relate to ground 1. The 5th relates to ground 2, justification. We say, of course, that this doesn't arise. Thank you. We say, of course, that this doesn't arise, and we will be submitting that the issue is really as to the extent of positive obligations under Article 11.1, and that that should be the focus of the court's analysis. But if we're wrong, we say that justification is established under 11.2. And 6th and finally, even if we are entirely wrong about Article 11, we say that the definition cannot be read down under Section 3 of the Human Rights Act. Reading out what this court has said is the sole test under the section would go against the grain and contravene a fundamental feature, indeed the only feature of the legislation. Now, dealing with the first issue, riders are not in an employment relationship with Deliveroo. I propose to look at this on an analytical basis in a moment, but may I say a few prefatory words. The appellant has to show that the Strasbourg court would regard these individuals as being in an employment relationship with Deliveroo. And we say there's nothing in the case law or the materials which sends that message. But standing back and just looking at big picture for a moment, it would be an extraordinary conclusion. Just take for a moment one factor: the freedom to compete, or as it's known in the trade, multi-app. As you've seen, it was accepted that a goodly proportion of riders did this, and you may say to yourselves, why wouldn't you do it if you were a rider and you're being permitted to do it? And being able to compete doesn't mean what it often means in a contract, that when you go home in the evening, outside your working hours, you can then do something in competition with the counterparty. What it means here is that you can turn down the offer from Deliveroo in favour of one of the competitors. You look at your apps, well, that job's nearer my house, I'll take that. Or that one's being better paid, I'll take that. I'll do Just Eat's job instead of Deliveroo's. I'll do Uber Eats' job instead of Deliveroo's. And if I finish those orders, I may not do another order for delivery today or tomorrow or the next day or ever. But if I do add in another finding, I can wear the competitor's kit. I can go along and fulfill a delivery order wearing all the gear of Uber Eats. And individuals did that. There was some photographic evidence at the CAC and some rather bemused customers receiving people from kitted out in a garb from which they didn't think they had ordered. And that was a very common phenomenon. Or I might get somebody else whom Deliveroo doesn't know at all to do the job. Even leaving aside substitution, relations are structured so that riders can work if they choose, when they choose, and with whichever company they choose. And I do not know of any arrangement ever where an individual has been able to say to the counterparty, I'm going to do a competitor's order instead of yours, where they have been classified as being in any kind of employment relationship. It is the absolute counterpoint of an employment relationship that not only do you not have to be there, but if you choose to turn up, you can damage the counterparty's interest by serving a competitor. These things don't happen in employment relationships. There are a million reasons why this case is different. Indeed, it's got almost no similarities from Uber, and I may touch upon those later. But this is definitely one of them. The poor old Uber driver tends to be a 9 to 5 man or woman, and at the time of the case there was absolutely no question of multi-apping. You just had to do one Uber order after another in a car suited to Uber, subject to Uber's performance assessments and so forth. And these individuals are as free as the wind. And it shows. I don't want to disappoint any of your lordships or your ladyship if you were planning to apply to do some of this work, but there is a waiting list. In London, you would have to wait over a year to be onboarded by Deliveroo. This week, I'm told, there are over 500,000 applicants on the waiting list. This is special work. It has a special flexibility and privilege which appeals particularly to young people who like to operate their lives flexibly, don't want to worry about what they wear, don't want to worry about having loyalty to any one organisation. Deliveroo riders are like no others, except possibly riders of some of their competitors. So we say one shouldn't start this analysis by any sense of surprise at the outcome. We appeared before what I would describe in the very best sense as a very sceptical tribunal, a highly skilled tribunal with a lot of experience in employment relations. Mrs. Justice Stacey became the chair and I think the president of the Industrial Law Society. Mr. Leahy had been the president of the TUC, and they were rightly questioning about the reality of the arrangements and whether there was the freedom that they appeared to be. And by the end of the case, they were convinced. You've seen their conclusion. This isn't, as we had perhaps thought, anything like Uber or City Sprint. This case is clear-cut, and it's clear-cut as a matter of not only UK law, substitution consideration, but also Article 11, looking at the position more widely.
Was there any discussion before the committee as to whether, assuming that the different competitors, Deliveroo, Uber Eats, etc., assuming they are not colluding in any way as to how much they pay the riders, was there any discussion about whether the ability of the riders to accept work from other competing delivery companies operates to increase payments and redresses to some extent the imbalance of power to which Lord Hendy was referring?
I can't say there was explicit discussion, but it was implicit in a lot of the evidence about what's called surge pricing. You've heard some reference to it. If there is a high market demand in a particular area, the football's on and everybody wants a Chinese takeaway, then the price goes up, and there is clearly competition between the different companies. And Deliveroo's commitment is to provide the riders with what they want. The Chief Executive Officer started the business by doing the deliveries himself, and he still does it sometimes. And the ethic of the business... He's
not presumably relying on that income, though, to support it.
I think that is a fair comment. But the fact that Deliveroo was prepared to give so much away, okay, you compete, wear what you like, never have to turn up, never have to go through, attend a meeting of any kind or do anything, is a reflection of focusing the business on rider need and trying to attract young people in particular in preference to the rivals. And they've been hugely successful, hence the 500,000 waiting list.
Is the 500,000 waiting list supported by any evidence?
So, sorry?
Is the 500,000 waiting list supported by any evidence?
No, well, simply what I've been told is the position this week. We were asked during the hearing, though, and we gave whatever was the current figure at that point.
Yes, I see.
Yeah. So, what are the relevant criteria? Well, the cases don't tell us very much, do they? If we go to the Good Shepherd, or Chelbun, I'll attempt a Romanian pronunciation, Romanian speakers. That's at tab 64, page 2954. The bit to which I'm going is 2954. And paragraph 141, the court says it's not the court's task to settle the dispute between the union's members and the church hierarchy regarding the precise nature of the duties they perform. The only question arising here is whether such duties, notwithstanding any special features they may entail, amount to an employment relationship, rendering applicable, my Lord Stephen's point, the right to form a trade union within the meaning of Article 11. In addressing this question, the Grand Chamber will apply the criteria laid down in the relevant international instruments. See Mutatis Mutandis Demir by Akara. In this connection, it notes that in Recommendation 198 concerning the employment relationship, the International Labour Organization considers that the determination of the existence of such a relationship should be guided primarily by the facts relating to the performance of the work and the remuneration of the worker. So pausing there, that's one specific point it takes from Recommendation 198, and of course it's entirely in line with AutoCleanse and later Uber. You look at the reality to see what the terms are, and that's what the CAC did at first instance here, and that's never been in dispute.
And how does that compare with the domestic test? That's page 723.
It is substantially the same, we would say. Lord Justice Underhill suggested that it was in the Court of Appeal, and we don't dissent from that. You're looking at the reality of obligations, not what's in the contract as such. That being said, the contract is still a relevant framework.
296 subsection 1b has a sole test, and the Strasbourg court in the Good Shepherd case has a multifactorial test.
Yes.
So how does it stand?
The UK has a multifactorial test too. It's Lim A. Right. It's a contract of employment test, right, where you look at risk of profit, risk of loss, chance of profit, ownership of materials, extent of control, and so forth. And that is the normal focus. And Lim B is a special extension allowed slightly unusually in UK law, whereby if you don't think you can bring yourself within the multifactorial test in A, then you have a go on what is really a single factor test under B. Now, it's relevant to note in answer to your Lordship's question that the claimants accepted that they couldn't bring their case under A. I'll give you the reference. It's page 282 at paragraph 92. So that's bundle 1. So if we go to page 292.
This is the Appellant's case.
Sorry. 282, I'm sorry. Go to 282.
What is the document?
Paragraph 92.
Yes, what is it?
It says, this is the part of the decision of the CAC.
Right.
I'm so sorry.
Thank you.
So in the decision of the CAC at paragraph 92, second line, it was also common ground that it was not a contract of employment, and Lim B of section 2961 was the only potentially applicable subsection. So the claimants had foregone the multifactorial route and they had applied to bring themselves within the special UK extension, which is Lim B. Now, I say special UK extension because, as your Lordships and your Ladyship may be aware, most countries, certainly in Europe and I think the world, have a simple bifurcation. One category they may call worker or they may call employee. The other category they call employer. This third category, this subspecies, is a British invention, although it is mirrored in one or two other countries. But when we look at an EU case later on, the Kinston case, we'll see that they are focused simply on a bifurcation between employers and workers with no Lim B extra. So what that brings to this case is that it was the claimants who were denying themselves a multifactorial approach by accepting they couldn't satisfy it. Why did they accept that they couldn't satisfy it? Well, we'd suggest because they didn't have a case. There's also the fact that they might have exposed the claimants to some tax liabilities if they had gone behind the contractual position in that respect and claimed that they were employees under Lim A. Because Lim A corresponds very largely to the definition of employee for tax purposes, and whilst it's sometimes suggested that there might be different considerations applicable to the tax regime as against the employment regime, I've yet to see a single example actually being identified in practice. It's very much the same multifactorial test. But whether it was because they wanted to protect their self-employed status for the purposes of the tax regime, or whether, as we suspect, it was because they felt they had no case on a multifactorial basis. They could have gone down that route, and they didn't. Now, back to, if we may, Chelbun, the Good Shepherd. I was looking at paragraph 142 in Bundle 8, Bundle 9.
Yes.
So the Good Shepherd begins at 2938, and I was on page 2954.
Yeah.
And we'd noted the fact, which led to the court's helpful intervention, we'd noted the fact that there was one particular thing which had been pulled out of the ILO recommendation 198, which is effectively the test has to reflect the reality, notwithstanding the characterization of the relationship. And then it goes on, in addition, the ILO's Convention number 87, which is a principal international legal instrument guaranteeing the right to organise, provides in Article 2 that workers and employers without distinction whatsoever have the right to establish organisations of their own choosing. And that doesn't tell us much, does it, about the content of employment relationship. Lastly, although Council Directive 78/2000/EC, that's the what's called the Framework Directive. I'm reading from 142. Paragraph 142 on page 2954.
Thank you.
And the last section there, although Council Directive 78/2000/EC, which is what's called the Framework Directive, which deals with discrimination in Europe, accepts the existence of a heightened degree of loyalty on account of the employer's ethos, it specifies that this cannot prejudice freedom of association. Now, neither of the latter points tell us really anything about the content of employment relationship. All we know is that the Grand Chamber will have regard to the general trends and tendencies, and there is one particular matter in Recommendation 198, which I'll call the reality point, which it adopts specifically. But it would be absurd and impossible to suppose that it was swallowing Recommendation 198 whole, or transmuting what are at most tentative suggestions about possibilities for member states into hard-edged rules which are to apply in every case. There's not a hint of that. If we could turn up the recommendation, which is tab 79, begins at 3135, and the key section starts at 3137. If your lordships and your ladyship have that.
Sorry, can you just give the page again?
Not to bound ahead again.
Sorry, page. I missed the page number.
Sorry, 3137.
Thank you.
Is the relevant bit. Paragraph 9 is the bit which the court does adopt. Ignore a contrary characterisation, look at the reality. Paragraph 11 simply directs that 3 possibilities be considered. It's only a possibility that a broad range of means for detecting the existence of an employment relationship is to be adopted. You have the liberty to restrict yourself to 1 or 2 factors. Providing for a legal presumption that an employment relationship exists where 1 or more relevant indicators is present. Well, all it's saying is that member states can consider that possibility. And had the court in the Good Shepherd intended to say that such a presumption applied, it would surely have said so in express terms. It wouldn't simply, by a historic reference to this amongst other conventions, have said, have intended to convey that there was a legal presumption of an employment relationship. And then thirdly, determining following prior consultations with various people that workers of particular characteristics must be deemed employed or self-employed. Really the plea there is simply for clarity. As to the particular factors in 13, I can't claim, although I would like to, that the court is adopting those as some kind of definitive list. I think it's a matter for your lordships and your ladyship, but you may think that it's, given that none of the other instruments give any guidance at all, that the court clearly would have found these indicia helpful, but even I can't say, though I would like to do so, that they are a definitive list. If one looks at the individual elements, first of all, in A, the fact that the work is carried out according to the instructions and under the control of the other party. Well, these individuals accept offers. They aren't instructed. Once they accept an offer, they've got to achieve the objective, just as every commercial party has to. But they can take their own route, see para 72 of the decision, on their own equipment. They have to use their own equipment, their own bike, their own phone, in their own, and that's para 56, and in whatever clothing they like. And it's extraordinary to describe that as operating under instructions. It's an offer which is either accepted or rejected. And he can even give up. He can hand the job back after acceptance without an excuse, without sanction, without question. Okay, I don't feel like it after all. He can hand it back. It's absurd to describe that exercise as a controlled one. As to integration, they don't have to attend premises or meetings or do any work or schedule themselves. They are free as birds to turn up, not turn up, go to the pub, work only in student holiday time or any of the other things. They don't have to give any advance indication, paragraph 67 of the decision. The only criterion listed here with which there's any question or difficulty is the proposition that the work is mainly for the benefit of another person. That one would have thought was philosophically debatable. One would have thought that both the recipient of the meal and Deliveroo and the individual would regard it as a mutually beneficial arrangement, and the fact that the individual has choice as to whether to take it up or not surely influences that analysis, but that, even by international treaty standards, is perhaps a little abstract and opaque. But all the other considerations are not met, must be carried out personally. Note the word must. That is certainly not the case. The substitution clause was underscored by a letter, paragraph 54 of the decision on page 270, underlining the ability to substitute. Within specific working hours, no. There are no working hours at all. Of course, a restaurant needs to be open somewhere, but that's not working hours. They don't have to work in any hours at all. At a workplace specified by a counterparty, no, they can turn up anywhere. The finding is they can work in any zone. They just have to switch on. Zones such as Camden have been abolished anyway. Work is of a particular duration? No. It's not even the duration of a delivery, because they can give up if they want to in mid-delivery or pass it to a friend. Does it have a certain continuity? It has no continuity whatsoever. That's what they like about it. Are riders required to be available? No. There's specific finding that no one was terminated for not making themselves available. paragraph 77. Equipment, bike and phone provided by riders, and the other equipment, the box and so forth, has to be acquired and paid for by the riders. So A is a complete failure so far as the riders are concerned, and so is B. There is no periodic payment. You only get paid if you've turned up and done some jobs. I mean, the fact that as a matter of accountancy it comes every 2 weeks doesn't make it a periodic payment in the sense that's intended there. That's asking about wages, isn't it? And this is not that case. Typically, it's not the sole or principal activity. All will be done around student or caring roles. There's evidence about that, and the tribunal expressly finds that some riders do fewer intermittent jobs, and others do more around their other commitments. Quite a significant reference. There are no benefits in kind, no rest or holiday rights, no travel expense provision, no protection from risks. They have to insure, so the risk does lie on them. And there's not a single factor that is satisfied. And that is before you come to what I gently suggest might be the strongest factor of all, the fact that against this background they can compete, they can accept the rival's offer in preference to Deliveroo's, and thus, as it were, simply decline. Not to follow an instruction, because there are no instructions, but simply to decline the offer of work altogether. And that matter isn't listed in paragraph 13, I would respectfully suggest, because nobody, nationally or internationally, would have considered the possibility that you could be in an employment relationship and still prefer to work with the counterparty's competitor, and to turn down orders for the counterparty in favour of the competitor. And we say it's not within a country mile of an employment relationship. There's nothing in the Strasbourg authorities to indicate that the riders would be. And the EU position, which I'd like to come to tomorrow, because in my submission it is very informative, is precisely that individuals in this sort of arrangement are resoundingly not in employment relationships. I think that is probably a convenient moment, if it's convenient to your lordships and your ladyship.
Certainly is. Thank you very much.
Thank you.
We'll resume at 10:30. Thank you.
Thank you.